Good evening, everybody joining us. Coming into the room, we're going to take just a few minutes, a couple of minutes to make sure everybody gets in. We have a fantastic turnout tonight, so bear with us while we have a couple of minutes of silence while everybody gets settled in the room. We should invest in some hype music. Get everybody going while everybody gets in the room. It would be Hamilton. Yes, sir. Greeting everybody who's coming in. We're taking just a few minutes to make sure everybody gets in. You're still about a minute early, and we have a big turnout, so we're going to let everybody get settled for just a couple of minutes. Everyone, it's 5:30. We're still waiting for everybody to get into the room, get settled. Thank you for joining us. I'm going to give it till about 5:31 before we start in earnest. So thank you for joining us, and hang on for just 1 second. We'll get started. Everyone, thank you for joining us this evening. We still have folks who are coming into the room, but just in the interest of time, I'm going to start getting underway just a little bit. I'm Jeff Baker. I'm a professor at Pepperdine Caruso School of Law, joined by my colleague, Judge Tiffany Williams tonight, and our Dean, Paul Caron, in just a moment. And I'm going to get started in just a second, still letting people get settled, but I want to take this time to welcome you all. I'm coming to you live from our courtroom at the law school, trying to bring a little gravitas to the proceedings tonight. I hope I can pull that off in this Zoom environment, and we are very glad to have you. I see folks still coming in, and while people are getting settled, I want to take just a few seconds rather, to give some credits at the top and to thank everyone who has had a role in getting us underway tonight. I want to thank our Vice Dean, Naomi Goodnow, who leads our Diversity Council and our ad hoc groups, including our MICA 6-8 group, where this idea was born several weeks ago, for her unfailing support. I want to thank Jessie Fay, our Director of Alumni Relations, and one of the important leaders of our Paris Institute, and her staff, especially Lauren Holm, who's on the line with us tonight. They have been integral in getting us started and getting the word out to our Alumni Association and to help us with some of the CLE management. So thank you to Jessie and her crew. I want to thank Kelly Kamamoto, our clinical program manager. She is just indispensable and makes everything go for us and is behind the scenes tonight as well. I want to thank Michelle Feinstein and Sophia Hamilton from our CDO and our externship office, who also helped promote us out into the world tonight. I want to thank David Dickens and Jonathan C. For their IT help and Zoom work. And then I want to thank Margaret Barfield on our staff for her help getting us approved and underway for CLE work. And last for this evening, Beatrice Lasud is providing our captioning. And if you would like to have this information captioned, this evening captioned and see what we're saying, you can click on the link, as Kelly has said, in the chat. And last, for credits and thanks, I want to greet our Dean, Paul Caron, who leads our law school, and am grateful that Dean Caron has been able to join us tonight and will offer a couple of words of welcome to us as we get started. Dean Caron.
Thank you all for joining us. This program on the racial justice imperative and ethical lawyering is at the core of what we're about at Pepperdine and Caruso Law. When I became dean, one of the books that had the biggest influence on me was a book by Simon Sinek. The book is Start With Why. And the idea is that all organizations should think deeply about why they exist. What do they do that is their unique contribution to the world? We went through an exercise to determine our why. We came up with Pepperdine Caruso Law exists to ignite in our students a lifelong passion for law and love for others through a rigorous and transformative educational experience that launches them into impactful careers to honor God and change the world. I can think of no better way to live out that final line, to honor God and change the world, than the subject of tonight's program, the racial justice imperative in ethical lawyering. And I can think of no better people to lead us in this important subject than Jeff Baker and Tiffany Williams. So I'll turn it back to Jeff now.
Dean, thank you so much. We're grateful that you're here tonight, and thank you for your support to get us underway. We have a couple of logistical things before we get started. We have a big crowd. I see participants now are above 300. We have a couple more hundred who have registered. We are thrilled to have you here. In that spirit, we're going to not turn on your mics and cameras, just because you can understand in a Zoom environment that would be sort of distracting. And we have the Q&A available for people to submit questions and comments sort of as we go. But Judge Williams and I are going to hold all of those questions until the end. But send them in because we're monitoring them, and we'll make sure we have good notes at the end. But I will say to the question that someone has already submitted, yes, we're going to record it. And in fact, we are recording it, and we intend to have it available in some way soon. We have to figure out some of the logistics on that, but yes, we will. Now, another thing that we want to cover logistically before we get started are the CLEs and the CLE credit. This is approved for legal ethics credit in California. And if you will look in your chat box, you will receive a link to a resource link, page that will have our slides for tonight and their attendant links, and then some documents that you will need to fill out for your CLE credit. And we will submit, we will email to you a certificate and evaluation after the event. And if you'll complete the evaluation and keep the certificate for your records, you should be able to get CLE credit. And for our non-California folks, I hope that you can carry that certificate and get credit from your state. And if you're here just for the love, we appreciate that all the more as well. So I'm going to discuss and get us started in some introductions in our agenda. But first, I want to introduce Judge Tiffany Williams to you. She is has completed her first year with us at the law school, and is my dear friend and collaborator and co-teacher in many ways. She is upcoming with a new title and an exciting position called Associate Director for Advocacy, Empowerment, and Faith. Judge Williams, as you can see, is an extraordinarily accomplished lawyer, Deputy Assistant Secretary of State in New Jersey, a New Jersey Administrative Law Judge, Deputy Chief Counsel to the New Jersey Governor, Chief Counsel for the General Assembly, Assistant United States Attorney, and Associate at law firms in New Jersey. She is a brilliant lawyer and will be teaching legal ethics coming up this year as well, and has immense wisdom to share with us. And I'm just thrilled and honored to be able to share the screen with her tonight. I will not brag about myself too much. I'm a clinical professor of law coming up this year, Assistant Dean of Clinical Education and Global Programs. I direct the Community Justice Clinic. I'm in my 20th year of law practice now, just achieved my 20th year of law practice, started in my home state of Mississippi, where I was an associate at Watkins & Eager and litigation practice, 7 years running the clinics at Faulkner University, Jones School of Law in Montgomery, where I ran clinics for domestic violence and elder law, and now here at Pepperdine for 7 years running our community justice clinic and disaster relief clinic and other things. So that's us, and we're both teachers of legal ethics in many ways, and we're going to get started. And tonight, after our welcome and introductions, we're going to have two major components for our discussion tonight. I'm going to carry the first one, lawyers calling to promote racial justice in the law and the legal systems, asking this question and answering it. Do lawyers have an ethical duty to promote racial justice? Then Judge Williams will pick up and discuss this topic, the lawyer's duties to promote racial justice in practice, asking how a lawyer can fulfill our ethical callings and duty to promote racial justice in the legal system. Then we will end, time permitting, with some moderated Q&A. But let me dive in, since we have now set up our evening for the night. And since this is a legal ethics CLE, we're going to start with the rules. And I'm leaning tonight on the preamble to the ABA Model Rules of Professional Conduct, which are reflected in California's new rules, California Rules of Professional Conduct Rule 1.0. The comment reflects much of the content that is in the preamble. And the preamble includes a really artful discussion of all the things that lawyers do. Lawyers are, in our work, representatives, advisors, advocates, negotiators, evaluators, counselors, and we are also officers of the legal system and public citizens. And that's where I want to root my comments tonight, is in this idea of public citizenship. And those are at these links. And so when you click in and get to your slides, you'll be able to see it as well. But I want to highlight the language, and this is a little long. I'm not going to read it all to you, but I want to talk about this concept of public citizenship. Now, public citizenship is not sort of how we get paid. It is not the legal ethics that we often think about confidentiality and conflicts of interest, this sort of thing. Rather, it is the consideration that we owe to the world and to our nation and to our community by virtue of being lawyers. It is our professional calling. When we receive the trust of our clients, the wealth, the influence, the prestige, and the influence that we have in our system, we are called to public citizenship. And this is because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. So we should seek improvement of the law, access to the legal system, the administration of justice, and the quality rendered by our legal profession. Because frankly, if people don't trust us, if we're not doing the right thing, then the system will fall apart. In very real terms, as officers of the court and public citizens, we are essential to the administration of justice and, frankly, our entire republic and our constitutional government. And here's the conclusion. All lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all of those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. That is what we are talking about tonight. The rule of law in constitutional Republican democracy depends on us making sure that the law doesn't erect or maintain or substantiate barriers to justice. And I want to put this another way. and demonstrate to you another frame for this understanding. It's this: no taxation without representation, the motto of our revolution. This idea is rooted in our American DNA. And my dean, Caron, who's a tax attorney, will always appreciate that the American Revolution is built in tax law, right? And of course, we know what this is saying. The colonists didn't have a voice in Parliament. And because they didn't have a voice in their own government, then we rebelled, we revolted. And we get tearing down the statue of George III in Manhattan. We get throwing personal property in Boston Harbor in the form of tea. And we get an armed revolution because the British government was not allowing the American colonists to have a voice in their affairs. It is part of who we are. It is a founding principle. And as officers of the court and public citizens, we have a professional obligation to ensure that everyone who is governed by the laws of the United States and the laws of our respective states have access to justice, and access to justice that does not depend on one's racial identity, gender identity, one that is not obstructed by discrimination or bias or inequity. I want to show you another example of this. Dr. King, Dr. Martin Luther King in 1965 gave a speech in Montgomery, where I used to live, at the top of Dexter Avenue. This was after the Selma to Montgomery March. And the Selma to Montgomery March was a demonstration to convince Congress and Lyndon Johnson to pass the Voting Rights Act. Dr. King has this passage talking about how this movement had to happen on Alabama soil, that people were moved by the demonstration. And he says, from the wells of this democratic spirit, the nation finally forced Congress to write legislation in the hope that it would eradicate the stain of Birmingham and the 14th Street Baptist Street church bombings. He says the Civil Rights Act of 1964 gave Negroes some part of their rightful dignity, but without the vote, it was dignity without strength. The civil rights movement at this point was about voting rights, not just civil rights. And those voting rights were because of this. People have to have a voice in their own government if we are going to, and their own legal system, and our own system of justice, if it is going to sustain. Then Dr. King talks about what happens when that fails. What happens when people are denied their voice and their system, their franchise within our system. And in this context, in 1968, he was responding to critiques about riots, frankly, in urban centers throughout the United States. And this has been famous lately in our current system, but he says tonight, these conditions are the things that cause individuals to feel that they have no other alternative than to engage in violent rebellions to get attention. And I must say tonight that a riot is the language of the unheard. What he's saying is that people will rebel when they don't have a voice in their own system, when the system doesn't hear them, when the system excludes them. People will rise up. And they will rise up sometimes in ways that are illegal or are disruptive or are troublemaking. And in 1968, he says, what has the nation failed to hear? It has failed to hear that large segments of white society are more concerned about tranquility and the status quo than about justice and humanity. Now, am I condoning violence and uprising? No, but I'm understanding and suggesting that we all consider the just political physics at work here. When people are denied access to the system of government, then they will rise up. And our popular, as the preamble said, our system requires, quote, popular participation and support to maintain authority. Therefore, if people don't trust the system, they will opt out of the system. So I repeat, this is from the preamble. All lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all of those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. We are operatives of the rule of law. The rule of law depends on lawyers. But to round out my analysis, we have to think, if we have a duty to confront economic and social barriers in our legal system, are those issues, are those barriers racist? Are they rooted in racial identity? Are they rooted in segregation? And I'm going to say to you tonight, I believe unequivocally, yes. From 1619 thereabouts to the 1960s, racism and racial barriers to our system of government were enshrined in the law. They were explicitly in the law. Since the 1960s, we have continued to deal with the effects of that, of insidious, implicit legacies, cultural, social, the potential consequences of white supremacy, especially economic. And, you know, we are just basically one generation removed from the civil rights movement. And that is one generation after basically 16 generations of racism that was enshrined in the law. So I'm not going to try to make this case to you too much, but I feel the need to give some statistics. This is just one example. CNN reporting earlier this year that the median net worth of white households is about 10 times the median net worth of black households. That the median income of black households is a little less than 60% of that of white households. Unemployment rates, poverty rates, and a larger share of black Americans lacking health care compared to white Americans. Now, we can wrangle and we can fight and we can talk about a lot of things, but I'm going to suggest to you that this is because after generations of building wealth and having education and having housing and having all of the things that we know that came during the ages of segregation and before that in slavery, it sets a trajectory for our people. And that ends up having a profound correlation to poverty, and that poverty has a strong correlation to access to justice. That manifests itself in several ways. Black people are incarcerated in state prisons across the country at more than 5 times the rate of white people, and at least 10 times that rate in at least 5 states. You can read these for yourselves. Poor and minority groups are less likely than higher income counterparts to seek help for civil legal problems. That means they're not turning to courts, not turning to lawyers because they can't afford it or because they don't trust it. And roughly 3/4 of poor people do not seek legal help for their civil legal issues. And that inaction is more pronounced among Black people. We can talk about heirs property. We can talk about many, many examples of Black people and other people who are not white being excluded or at least being discouraged from encountering the legal system. And when people do not feel enfranchised within the legal system, then they rise up, or they create black markets, or they create self-help, or they just endure injustice as much as we go. And this is important to us in legal education. In 2020, 5% of Black first-time takers passed the California bar exam, compared to 52% of white takers, 42% of Asian Americans, and 31% of Hispanic takers. Now, we can talk about what that means, but something is amiss, right? Something is amiss in our educational and our economic systems that lead us to that place. So my point to you is this, and I'll summarize before I hand over to Judge Williams. Do we have a duty? Do we have a responsibility to confront racial injustice in our systems, in our law, and in our professions? Yes, we do, because the rules say so. And this might be the best and most important example of our tradition of professionalism, above and beyond what we do just in our day-to-day practice, but recognizing that democracy in our system of government rests on our shoulders. Then, does injustice rooted in race and racism still exist and affect our system? Yes, it does. Now, we may argue in good faith and in civility and in collegiality about what to do about that. We may argue about causes, we may argue about effects, we may argue about policies and what we should do, left and right, Republican and Democrat. We may struggle with that. We may struggle about how to address it. We cannot not address it. Apathy, comfort, ignorance complicity are not professional and ethical responses to racial injustice. So I will end just with these thoughts. Questions for you to consider. How does my practice advance my responsibilities as a public citizen? How does my firm, agency, and office expand access to justice? What can we do within our bar associations to advance and improve the situation? How should legal education in law schools improve to promote racial justice? And for each of us, how am I using my time, resources, and civic influence to ensure equal access to our system of government? That is where I'm going to pause now and turn it over to Judge Williams and ask her to share her screen, and we will keep going. Thank you all. Judge Williams.
Absolutely. Well, thank you, Jeff. And it's such an important topic that we're talking about this afternoon. And I just thank you all for taking the time out to examine what our role is as lawyers in the profession to promote racial justice. And do we have an obligation? So picking up on where Jeff left off, I'm just going to give a slight overview and framework of what we're talking about when it comes to racial justice, and then dive into a few more sources within the rules that we can perhaps rely upon as well. And finally, turn to different aspects of practice that we can really roll up our sleeves and start attacking racial inequities that we see both in the profession as well in the actual practice of law. So promoting racial justice, first and foremost, it embodies what I call an acknowledgement and a commitment. So the acknowledgement is that racial inequities in our legal system actually exist, and they undermine the very confidence that we have in the rule of law and the administration of justice. And that lack of confidence in the administration of justice actually undermines the Constitution, threatens our democratic freedom in a civil society. So that should be motivation for us to roll up our sleeves and start promoting racial justice as attorneys. It also takes commitment to advocate for revocation and, first of all, identification and revocation and eradication of embedded racial inequities in the legal system, because those are threats to equal protection under the law. We certainly also want to commit to remediation of past inequities as a means of achieving justice for those that the legal system has typically failed to treat equitably. So when we're talking about promoting racial justice, it's important to also remember that anti-discrimination and elimination of bias also promotes racial justice in our profession. And as Jeff talked about, the main premise in the preamble is really getting us to focus on how inequities impact the confidence that Americans have in the administration of justice and in our legal system. So looking at a few rules in the model rules, and every state has not adopted 8.4G. It actually was passed by the ABA in 2016. And some states have rules that actually go even further than 8.4G. But I have taken, and it covers different areas than just racial discrimination, but I've isolated the part that talks about race. So 8.4G makes it clear that it is professional misconduct for a lawyer to engage in conduct that they know or reasonably should know constitutes discrimination on the basis of race, in conduct that's related to the practice of law. And in the comment section to that rule, the comments talk about the fact that discrimination undermines confidence in the legal profession and the legal system. So judges also are not immune to this concept as members of the legal profession of promoting racial justice and finding an ethical obligation to do that in the ABA Model Code of Judicial Conduct 2.3 A and C. And by the way, these slides, as Jeff said, have hyperlinks to all the rules and some backup data for some of the statistics that we have pointed out as well. But 2.3 A and C talk about a judge's responsibility to engage in proceedings without bias or prejudice, and to actually require lawyers in proceedings before the court to refrain from manifesting bias or prejudice. So we also have a model rule of professional conduct 8.4D, which says that it's professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Now, states that have adopted 8.4D typically are concerned with diminishing public confidence and tainting the legal process. And I quoted here from a decision in Kansas from the ethics body there that says, all lawyers, by virtue of their licenses, enjoy the status of officers of the court. That status brings with it the responsibility to refrain from conduct unbecoming such officers, to uphold the rule of law, and to enhance public confidence in that rule and the legal system set up to safeguard it. And that really encapsulates our responsibility and the opportunity that we have as lawyers to promote racial justice, because in doing so, we're enhancing the public's confidence in the rule of law and in the legal system. So lawyers have a unique opportunity to promote racial justice, both in the profession and in our actual practice, and by doing so, to instill that confidence in the administration of justice. That's not a new concept. Justice Potter Stewart mentioned in one of his decisions, a lawyer belongs to a profession with inherited standards of propriety and honor, which experience has shown necessary in a calling dedicated to the accomplishment of justice. He who would follow that calling must conform to those standards. And in 1963, when Bobby Kennedy was Attorney General, he had a meeting with about 200 lawyers in the East Room of the White House. And he was calling for the establishment of lawyers' committees around the country to pursue civil rights. And we now know that organization to be called the Lawyers' Committee for Civil Rights. But he was arguing that day that members of the legal profession who have sworn an oath to the Constitution are obligated to advance the rule of law and use their specialized knowledge and skill to advance civil rights for African Americans. So we have opportunities within the profession if we believe that promoting racial justice, which we should, and Jeff made a great case for it, promoting racial justice is rooted not only in our obligation as attorneys, but certainly in what society is looking for lawyers to actually do. If there were not lawyers on the front line to promote confidence in the legal system, who would do it? So no matter what area of practice you're in, there are opportunities to promote racial justice. So I'm going to finish up by just going through some suggestions for opportunities in law firm practice, for those that may be government lawyers, for those that may be in-house in a corporation, and even for those like Jeff and I who are working in the legal academy and legal education. So when it comes to opportunities in law firm practice, some of these are not new, but they are areas where we should perhaps look at ourselves as attorneys and say, where have I known that there are some disparities and chosen to be silent, or maybe just continue with the status quo? So we're challenging you today to look at these areas with fresh eyes and with a fresh heart, and one that feels obligated, like you have a role, because you do. So increasing number of attorneys of color in law firms, it's at 16%. How do you do that? Firms have spent thousands of dollars over decades, hundreds of thousands of dollars in recruiting over decades to try to get at this number. But there are some best practices that are helpful to actually do the work to not only recruit attorneys of color, but to retain them as well. So adopting hiring and promotion practices that actually and intentionally reduce bias in the decision making. Having mandatory implicit bias training for hiring committee members or supervising attorneys that assign work and issue performance evaluations, because these are the areas that statistically we see that there are disparities for attorneys of color. A part of implicit bias training is often training on eliminating confirmation bias. So confirmation bias, you may be aware, is when you process information and you favor information that confirms what you believed before. And there's a famous study that I call the Thomas Meyer memo. And it's a study of 53 law firm partners who each were divided into groups, and some had to evaluate a memo by Thomas Meyer, and they were told that he was white, and the other group evaluated the memos by Thomas Meyer, who they thought was black. So what happens? The same memo that is rated by white Tom, who they thought was white Tom, got a 4.1 rating out of 5, whereas black Tom got 3.2 out of 5. White Tom was praised for his potential, while black Tom was critiqued as being deficient. One of the critiques that black Tom's memo said was, "Can't believe he actually went to NYU." White Tom's memo rated better for analysis and had fewer critical comments. Only 2.9 of 7 spelling errors were found for White Tom's memo, but 5.8 of 7 spelling errors were found for black Tom. That is a function of what we call confirmation bias. And so educating law firm partners and associates that are on hiring committees or supervising attorneys, writing evaluations, to dig deeper into where bias may actually exist within them and in their practices is a way that we can actually promote racial justice and increase the number of attorneys of color that are successful and retained in the practice of law within law firms. There are also lots of initiatives that affinity groups for attorneys of color actually are able to provide for support that also helps to increase retention. And staffing those affinity groups and giving them real resources for professional and business development opportunities can be a key part of promoting racial justice as well. Certainly having zero tolerance policies for backroom and closed door discussions, either internally or with clients that promote bias, that ties us back to the conduct that is considered misconduct in the practice of law in Model Rule Professional Conduct 8.4G, is another way that we can promote racial justice, not allowing certain types of discussions to happen in front of us in the course of practice. Increasing the number of attorneys of color that are partners is only at 9%, and the numbers for attorneys of color that are on executive committees or practice area chairs and hiring committee chairs, they're even smaller. So evaluating the firm's culture and structural changes that may be needed, really looking at how current practices within a firm are impacting attorneys of color. If you see that attorneys of color are not always getting a work allocation that will allow them to get the sort of recognition that will have partners be able to vote for them and know their work and know what they're capable of when it comes time for partnership. If we see it's always the attorneys of color that are falling in that category, that means that we need to evaluate the firm's culture and make some changes intentionally. And one other example that I put here is consideration of forming consortia of law firms and legal organizations to share best practices. When I practiced at Mintz Levin in Boston, Two Levin Partners had started what used to be called the Boston Law Firm Group, now called the Boston Lawyers Group, that does that. And I have a link here to that as well. When it comes to the actual practice, using law firm resources, and the same for corporations using corporate counsel budgets, to engage in active pro bono representation promoting racial justice. The examples that I give here are one of the most crucial areas of racial inequities that require pro bono representation, and that is representing death row inmates. Nationally, 42% of death row inmates are Black, 13% are Latinx. California and Texas still lead the way with numbers on death row, and you can see that 261 death row inmates in California are Black, 95 in Texas are Black, and African Americans represent the largest racial representation on death row. And even when it comes to exonerations, the leading numbers of individuals that are by race that are exonerated are Black. 16 are Latinx. So people of color are also getting accused of crimes of the highest magnitude wrongfully. So your participation in pro bono representation in that area is an important way to promote racial justice. I have some examples here of individuals and links to more about their stories as well, who are living examples. Anthony Graves in Texas, on death row for 12 years, 18 years incarcerated in total, despite there being no physical evidence tying him to the crime, no criminal history. We often see African Americans who fit these types of descriptions who are exonerated. You may be familiar with Walter McMillan's story, where Brian Stevenson represented him. Walter McMillan was on death row from the time that he was arrested. There are lawyers involved in the process that should not have allowed that to happen. Walter McMillan is actually from my hometown where I was born, Monroeville, Alabama, and was the uncle of my aunt by marriage, if you follow that. But his story, and Anthony Graves' story, and many, many more, are living examples of how justice goes wrong, how the rule of law can be compromised, and how lawyers have a unique role to promote racial justice, where we see that there are significant disparities. And we have the opportunity to restore the confidence in the administration of justice to individuals who typically have not been served well. I have some examples of some other firms that are working on death row cases, and a recent article I saw that the firm Foley and Lardner took an innovative step to announce the formation of an actual practice group called the Pro Bono Racial Justice and Equity Practice Group. So that's a strategy that can be employed as well. Lawyers in government service, prosecutors, public defenders, court-appointed private counsel, and even judges have that unique vantage point and special opportunity sometimes to really see disparities and racial injustice. The prosecutor in Anthony Graves' case, he was a 20+ year veteran, he was actually disbarred because of his conduct in the case. And when Anthony Graves went to even bring this case to the ethics board, there were volunteer lawyers that prepared the petition for him as well. So these are opportunities too that you can get involved on a pro bono basis. And counsel to legislative bodies and state executives also have an important role in being able to advise policymakers on promoting racial justice. When I was counsel in the Assembly in New Jersey in 2017, New Jersey became the first state to abolish the death penalty. And in my role as counsel, I was able to keep the legislators focused on the racial disparities in the implementation of the death penalty as a prevailing public policy reason why we should actually go ahead and be the first state in the nation since the reinstatement of the death penalty to abolish it. So corporate counsel, very similar to law firm practitioners have the opportunity to also use resources for pro bono representation, to really look internally at why there are so few attorneys of color even in the corporate counsel ranks, and also putting muscle behind the mandates to law firms to staff matters with diverse attorneys as lead counsel is a significant step to promote racial justice in the practice. 2019, there were 170 GCs that penned an open letter to firms, essentially, recommitting. There had been an earlier letter in the prior decade. So we see this practice over and over, that corporate counsel are trying to leverage the fact that they're not going to give business anymore to firms that are not diverse. We have seen that over time, but we're still not really seeing the numbers change so much. And we're also seeing even classes of law firm partnerships at firms become partners with no people of color, and they're still representing some pretty significant corporate clients. So putting some more muscle behind that and actually changing representation immediately with firms that can't produce and continue to promote classes of new partners with no attorneys of color. And certainly corporate counsel have the ability to really emphasize the shareholders' interest in the corporation of having attorneys of color's perspective in advising the company, because those perspectives reflect the market that's served by the business. These are just a few more statistics on the importance of recruitment and retention for promoting attorneys of color. There's such a dearth of attorneys of color that are general counsel and senior counsel. So there's a lot of work to do to promote racial justice also for in-house lawyers. And finally, for those of us that are dedicated to empowering the next generation of lawyers, we certainly have the ability in the legal academy to promote racial justice by developing course offerings and curricula and programming that's steeped in teaching law students now how to evaluate where disparities exist and what are the legal impediments to racial justice, telling them about the lawyer imperative to combat racial justice, and also law schools investing in that not just being lip service, but actually having staff to oversee that function so that it's institutionalized as well. Certainly considering implicit bias and cross-cultural competency training for faculty and senior administrators, staff, and students in a law school is a great way to be able to prepare law students to enter the profession ready to tackle their opportunity to promote racial justice in practice. Similar to firms and corporations, law schools also have to look at and reevaluating admission standards, considering looking at the biases that may be implicit in those that are making decisions on admissions applications, and truly looking at why are students of color not being admitted to the institution and taking steps affirmatively to change that. Certainly mitigating economic disparities for students of color through grants and scholarships is important, and recruiting and retaining and promoting tenured faculty of color is certainly an institutional way for a law school to show its commitment as well. I'm going to actually turn it back to Jeff to just talk a little bit about how in the clinical realm, since he is the director of clinics here at the law school, that we can promote racial justice in the academy.
Thank you, Judge. We're working in our clinics all the time to figure out, how to do this. And in fact, one of the questions that just came in over the Q&A, which I'll use it to jump off of from Ruth Gow, says, in the educational and clinical context, are there organizations that are tackling racial justice in the transactional context that we may engage with, particularly with an international bent? And I'll say that in legal clinics, we are working at Pepperdine. We're working downtown on Skid Row with people who are homeless. We have a tax clinic. We have my transactional and human rights clinic. We've got mediation clinics, domestic violence clinics. civil rights appellate clinics, not all of them have a specific focus or a specific mission on addressing exactly racial justice. But I think what we're trying to accomplish is what I think all lawyers are trying to accomplish or should, which is to try to use every practice area that we have to empower our clients and to model what professionalism is and ought to be. And so through our clinical programs, externships, we create opportunities and partner with people throughout the bar to plug our students into a place where they can to do this work. And if they are called to be righteous prosecutors, we put them in righteous prosecution offices. If they're called to be public defenders, we can find places to put them in public defense. And we take very seriously, as the dean said earlier, in producing law students who are committed to this, but also know how they can approach these things in their ways, even if it's not specifically focused on a specific issue of racial justice, such as disproportionate sentencing, et cetera. But to the question for my last example on that, on transactional work, my clinic works with a lot of nonprofits who are working around these issues, around homelessness, around human rights, around social justice issues, and working with them in a transactional and corporate practice to build the best kind of structures that they can and to extend expert legal services to people who may not otherwise be able to afford it. And I don't want to get out ahead of myself now, but we're having active conversations within a couple of quarters of our law school to think about establishing a clinic that is directly related to community economic development with small businesses among minority business owners and underserved and marginalized communities within Los Angeles. So I think the sky's the limit about how creative we can be and should be. Thanks, Judge.
Awesome. So as we wrap up, we just wanted to give you formally a call to action. So lawyers have historically been at the forefront of shining a light on darkness and tearing down walls of injustice, one brick at a time, and we want you to continue the work. So looking for racial disparities in the law, in the legal system, and in access to justice, including in the profession as well as in legal education, is one call to action. Second, looking for whom the justice system does not appear just, or who may not have confidence in the administration of justice. Looking at centers of power where power is tightly held without transparency and accountability. And most of all, start within your realm of power and influence and work outward from there. And if not now, when? And if not you, then who? So I will close my portion tonight with a quote from the Reverend Dr. Martin Luther King from his I Have a Dream speech. We have also come to this hallowed spot to remind America of the fierce urgency of now. This is no time to engage in the luxury of cooling off or to take the tranquilizing drug of gradualism. Now is the time to make real the promises of democracy. Now is the time to rise from the dark and desolate valley of segregation to the sunlit path of racial justice. Now is the time to lift our nation from the quicksands of racial injustice to the solid rock of brotherhood. Now is the time to make justice a reality for all of God's children. It would be fatal for the nation to overlook the urgency of the moment. I submit to you that the time is now for promoting racial justice in our profession. Thank you.
Amen, Judge. And we have, well, there's our contact information. We can click going. We can click off. Please feel free to reach out to us whenever you'd like. So grateful for you. We have a few questions that have come in over the transom for Q&A, and we've got just a few minutes left. And Judge, I'd like to raise this one to you too. You may be able to click on it and see. And it's a little bit farther down, but it's a good transition from what you've already mentioned. It's from and forgive me if I'm getting names wrong because I like to honor everybody, but it's Tom Felady or Felady. Please forgive me, Tom. But the question is, can you expand a bit on how underrepresentation of attorneys of color in the bar can be related to implicit biases in evaluating prospective applicants and how to overcome it? I have some thoughts on that, but I would love to hear yours first since you addressed it in your presentation already.
Sure, and I'll give you time to answer as well. The whole concept of implicit bias is really about how your mind categorizes information and the familiarity that comes to that. So do we feel more familiar in evaluating candidates, for example, who went to our law school, who are reflective of having been involved in organizations that we were involved in? And are we just going with who we feel comfortable with and not recognizing that maybe we feel comfortable with a very homogeneous group of people? And if we keep, and just looking frankly at the numbers, what is the impact of us making decisions and having the profile of the candidates from a hiring perspective that we typically have? So you promote racial justice by actually looking critically at, are our decisions that are resulting in a diverse pool? Our society, your clients, especially if you're a law firm representing corporate clients, your clients are expecting you to have diverse attorneys at the table. So you have to look at, are our decisions resulting in producing diverse attorneys? And if they're not, is it possibly because there are some implicit biases that we are subject to? I'll leave it there to give you some room as well to talk.
Sure, and I'd like to say this about implicit and explicit biases. I believe, I teach this and have exercises with my students on this as well, that I believe that one of the key points here, and one of the most practical things we can do is just to admit that they're there and to recognize them. I think we all have different forms of biases. Sometimes those are social and racial and racist. Sometimes they're otherwise. Sometimes they're, just what we were raised to favor, right? So I think that one of the keys that we have here is not necessarily trying to evacuate every bias that we have, but just to recognize that we have them and then be able to ask better questions, to work around what it is that we want to achieve, and to recognize that we erect our own barriers in our minds. And here are a couple of those. I think that and this may be an admission against interest from our law school, but I don't think so. I think we look at a lot of things as proxies for success before we actually get to know someone. Where did they go to school? What was their GPA? What law school did they come from? Are they on law review and moot court, et cetera? What firm did they get? From where are we poaching people? And those have some utility, but they're also a function of systems that send people in particular trajectories. I was having a conversation today with friends from my high school 20 years ago, no, more than that, 30-something years ago, in Mississippi, and some of my classmates in Mississippi who are Black saying that they were actively discouraged from taking AP classes, actively discouraged from taking college track classes because they were poor Black kids. And those have generational effects that push out for longer and longer. And so sometimes the things that we look at for success are actually proxies that just indicate forms of privilege and wealth and a family structure that allows people to get where they're going. And so I would say look deeper, and I think that's consistent with what you just said, Judge. That people need to look deeper and learn people's stories and recognize that it's in their own interest to get this right. If I can, I want to turn to another question, and maybe I can jump off on this one and then leave it to you to maybe wrap us up. We're not going to get to everybody, and I'm sorry, but one of the questions at the top is. And Mr. Patton, I'm going to say it like you said it, and then I'll maybe a little bit more politic because of my own biases. But do California Supreme Court justices have an ethical duty not to create a racial barrier to the practice of law by promulgating an unnecessarily high and unreasonable bar exam cut score. Well, I mean, like, so just personally, me, not the Lord, yes. I think that's really problematic. Of course, I took it and it was hard. But I think that your question gets at something related to what I just said, and that all these things are wrapped up very much. I have a beef with the bar exam because I don't think it tests for what lawyers need to know. But I also think that it's one more barrier among several barriers that end up discouraging diversity and discouraging inclusion in the system. And I will say that we have anguished in very serious conversations at our law school about how to address debt, about how to address admissions, about how to build pipelines. We're working on partnerships with HBCUs. We are trying very seriously and listening to our students to continue our efforts, because I think it's a bar exam problem, but I also think it's a law school problem. But I also think that it's an undergraduate problem and a high school problem. And I think that all of these things are related, and we have to be very creative to figure out how to ensure success in ways that don't just perpetuate systems that we have found to be wanting. Judge, would you like to pick up from there?
I think that's a great answer. The only thing I'll add to that is I do think that those that promulgate standardized tests that show historically, repeatedly, consistently, and over time that there are disparities in how the test performance is impacted based on race, who does well, who doesn't consistently. I do think they have an affirmative obligation to look at that, especially when it impacts who can practice law.
Let's see, I think we have, actually, I think we might be out of time. I want to honor everybody, and we're coming up with 1 minute left. So if it's okay with you, I'll try to wrap up. I want to thank you all. You have responded with some great questions that we weren't able to get to. We're trying to do this ambitiously in 1 hour just to continue and perpetuate and accelerate a conversation around these issues. I would say look at your state and local bars. And I believe very, very strongly that one of the most important things that we can do is to just build friendships and relationships, to not act in fear, but to act in love and some courage, to recognize with benevolent assumptions that we need grace in these conversations, and that the most important thing that we can do is to have them. And one of the most dangerous things we can do is to ignore them. Because we are still moving toward being a more perfect union, and it depends on lawyers and judges and all of us to make sure that we have arrived. Judge Williams, would you like a last word before we bid adieu to all of our friends here tonight?
I just want to thank everyone as my last word. And, you know, there are a lot of great questions in the chat as well. I'm sorry we didn't get to all of them. They are all very fascinating too. But as Jeff said, definitely tap into the local bars in order to tap into pro bono opportunities as well. And Gary, I do see your question here about what utility does preferential affirmative action have, if any, to promote diversity. That's certainly like a longer topic, and I think it also depends on how you are defining preferential affirmative action. But what I would say is, in promoting racial justice as attorneys, we should like clean the slate and look at any and everything that we have the power to do ourselves, and look at tearing down any system that is reticent to change, but clearly is a part of a broken system that does not instill confidence in the administration of justice in our citizens. So thank you, everyone. And thank you, Dean Baker.
Thank you, Judge. And I'll hope to see you soon in real life. And thank you all. Please reach out to us with any questions as you go. We're recording this, and we're going to look for ways to share it out again. Thank you, Dean Caron. Thank you, crew and team, for everyone. And we pray blessings over all y'all. Have a good night. Bye-bye.